Great. So I'm Elizabeth Gresk. I'm the Director of Pro Bono and Impact Litigation at the Legal Aid Society of Metropolitan Family Services. We're based here in Chicago. Today I'll be talking about short-term guardianships. It's a safety planning tool we recommend families use if they're at all concerned about parents, for whatever reason, being unable to care for their children or being separated from their children. So today's agenda will include kind of an introduction to the concept of short-term guardianship, the statute that it comes from, some vocabulary that I'll both be using and the form uses, and then we'll talk about what guardianship is and importantly what it is not, as there are some pretty significant limitations, the role that guardians play once they do become that guardian. We'll go over what the short-term guardianship form is and how to fill it out, and then I'll have some reminders and recommendations before we head into the Q&A portion. So as Diana mentioned, I am an attorney. I am going to be talking about legal issues and legal concepts, but nothing I'm saying today should be taken as legal advice or answering any of your specific questions. It does not create an attorney-client relationship between myself or our organization and anyone here today. If you do have more specific questions, our contact information is available at the end of the slides, and we'd be happy to talk in a more one-on-one situation. So with that, short-term guardianship is as I said, a safety planning tool that we recommend families use. It allows a parent to name someone to care for their child for 365 days in the event a parent is unable to. The wording on the form and the authority comes from the Probate Act of 1975, excuse me. And there's specifically an entire section of the act that relates to minors and guardianship of minors. The statute sets forth three types of guardianship. You may have heard of some of these. So plenary guardianship is also known sometimes as permanent guardianship or long-term guardianship. This is most similar to adoption in that it creates a permanent legal binding relationship between an adult caregiver and a child until that child reaches the age of majority. To do a plenary guardian, you do have to go to court. There's a lengthy process. There's petitioning involved. The families get evaluated. A judge has to approve it. So it's a much more intense process than the short-term guardianship is, as you'll see. There is standby guardianship, which is a 60-day guardianship, and it terminates at the end of the 60 days. And if a guardian feels they need to have guardianship extended for that, beyond those 60 days, they do have to go to court and again go through that more lengthy, involved process. That's most commonly used in situations where perhaps a parent is undergoing a brief medical procedure, expects to be completely fine, but just as a fail-safe, if something were to go wrong, they do have someone who's able to care for their child in an emergency situation. And then short-term guardianship, which is what we'll be talking about today, is valid for 365 days from the date it goes into effect, and I'll explain more about that. It does not require going to court. There are no fees or costs associated with it. It doesn't require registering the form anywhere or notifying any sort of law enforcement or state authority. So it's a really great tool that gives families security and peace of mind, but doesn't create additional legal exposure or interactions with agencies or organizations that folks may be a little bit fearful of, understandably, at this time. So short-term guardianship involves some particular language. So just so everyone's on the same page today, a parent is someone who is legally designated by birth or adoption to care for a child. So this means someone has to have been either listed on the child's birth certificate, has biological relationship to the child, or has adopted a child. We may have situations where children have multiple parent figures, people they may refer to as mom or dad or other parent language, but aren't legally or genetically related to them. And unfortunately, those people are not able to fill out this form. When we talk about a parent today and a parent completing the form, it is someone who has that legal relationship by either birth and genetics or adoption to a child. And so we also, again, in recognition that family structures all look very different and can look very supportive, even if not legally binding. If a a parent or someone acting as a parent in that parent role, but it's unofficial, they can't fill out this form. This is not meant to penalize parents. It's just how the legal system is structured. Um, and so if a parent knows they are not genetically or legally related to a child, they should not be using this form. A guardian is someone appointed to care for a child when a parent is unable to. That can be any type of guardian. In our case, we're going to specifically talk about what a short-term guardian can do. A minor is someone who has not yet attained the age of 18 years old. In Illinois and in common discussion, sometimes children go up to the age of 21, but legally speaking, and for the purposes of this form, it is the day they turn 18 is the cutoff of minority. And then administrative separation is particular language that comes directly from the Probate Act statute. And it is referencing immigration issues and deportation and detention and why a parent would need a form in those situations. So this is language that we recommend including on the form. You'll see in later slides where exactly to include it. But it talks about the two scenarios where a parent's involvement with the immigration system can trigger a short-term guardianship going into effect. And that is when a parent is arrested, detained, deported, or otherwise separated from their child, or they receive notice of an upcoming deportation or removal order, things like that. The big thing here is this vocabulary all is in support of the legal structure that we have for caring for children in Illinois and in the country broadly. So legally speaking, someone has to be in charge of a child. The default is the child's parents. And the law presumes you have at least one, if not two parents. In the event a child has zero parents able to care for them, a guardian must step in. Now, if a family is able to designate someone to act as that guardian, that's who we are talking about. But in the event a family is not able to, the state does step in. And in our state, that's the Department of Children and Family Services. So they do have an obligation to ensure children are cared for. So in the event a child is separated from their parent and no guardian has been appointed, DCFS does have a legal obligation to step in. So this is one of the reasons we really recommend people fill out this form is it is a way to ensure that children will not automatically go into DCFS care if a parent is separated from the child. So these are the scenarios where we recommend short-term guardianship forms be used. Again, the short-term guardianship only lasts 365 days. So it's great for situations where someone knows an end date or knows it's likely to be a short-term situation. So in the case of military deployment of less than a year, where a parent knows their start and end date, we can use the form. If a parent is going into a long-term medical care facility for either like physical rehabilitation, maybe substance abuse treatment, just a long-term surgery where they need inpatient care, this is again a great form. If a parent is incapacitated, so this would mean if they are, for whatever reason, unable to act as a parent and make those day-to-day childcare decisions for their child. This does not mean that a parent can't have a mental health diagnosis or a physical disability or other condition that may impact their parenting. It's if that condition is not managed and if it's preventing them from executing fully the duties of a parent, that's when we mean incapacity. Imprisonment, so if a parent is going to be incarcerated for less than a year, they can use this form. And then for detention and deportation related to immigration is the other scenario that we're most commonly using this form for. And that's what a lot of the discussion will focus on today. But if folks have questions about some of these other options, do please feel free to ask those in the chat as well. So short-term guardianship, as I've said, can be appointed without court involvement. It's a legal form. It's official and all of that, but it doesn't require going to court. It doesn't require you to pay an attorney. It doesn't require any registering or notifying anyone in a position of authority about the form. It lasts for 365 days from the day it goes into effect. So, depending on how the form is filled out, that's either a specific date or a triggering event, such as an administrative separation. The nice thing about the form is that, depending on the language you use, as if you use that administrative separation language, for instance, it's a future looking document. So, it will trigger upon the date of that administrative separation, meaning a parent can fill it out now and it's just a kind of like in the background as a fail-safe option for the family in the event a parent is detained or deported or separated from their child. It would go into effect at that future date. And that's part of the safety planning element of this is you can fill it out now, but use it later. The form is valid in Illinois. Each state has their own statutes and laws related to family law issues and things like guardianship. So each state handles this a little differently. So we recommend that folks fill out whatever form for the state that the child and the guardian are living in. Presumably that will be Illinois, but if it's not, we would recommend that parents look into whatever their particular state's rules and forms are. The form is supposed to be recognized by other states, but they're not required to because, again, they all have their own legal systems and approach to handling this kind of issue. And then a guardianship, short-term guardianship allows a guardian to make education decisions, so enrolling or disenrolling a child from school, participating in a child's academic meetings, special education meetings, 504 plans and IEPs, things like that. It allows a guardian to obtain medical care for a child, so that's both routine and emergency care. It allows a guardian to also apply for benefits for the child. Those are public benefits, so things like Medicaid, food stamps, SNAP, WIC. It does not allow the guardian to have any other financial powers related to the child, though. And one other element of this, with the 365-day limit, the form and the language in the statute does allow, in the specific instance for an immigration related separation, for the form to automatically extend for a second year if needed. So a parent can fill out a new form after 365 days if that's necessary, but for a parent who's been separated due to an immigration reason, they don't have to do that for until 2 years have passed. So, what short-term guardianship is not? This is really important because I think a lot of people are familiar with the concept of guardianship and maybe conflating some of the different elements. So, it's not permanent. It does expire after that 1 or 2 years in the event of an immigration-related separation. It's not court-approved. It's not any sort of long-term care arrangement. It also is not a parent's consent to a permanent guardian in the future. So, one thing parents may be concerned about is if they sign this form, they're saying this person should take care of my child. I have no further questions, no need to be involved. And that's not at all what this form is. So, a short term guardian cannot take this form to a court and say, look, this parent has given me authority over this child. You should make it permanent. It's an entirely separate legal process. And it would require a parent's involvement. So parents can rest assured that this form is only doing what's listed on it. Importantly, the short-term guardianship is also not one-sided, though. So both parents do need to be involved. They must agree to the person being appointed guardian with a few exceptions. So if the other parent is deceased, for obvious reasons, their consent wouldn't be needed. If the other parent's whereabouts are genuinely unknown, so either their identity is unknown or their location and contact information is truly unknown. So we're not talking about a situation where the second parent maybe lives in another state, is not involved in the child's care, but you still know where they are. You know how to get in touch with them if needed. That's not unknown. And it may be that you haven't talked to them in years, but they still are this child's parent and their wishes need to be considered. The other scenario is if a parent is unwilling or unable to make and carry out day-to-day childcare decisions. So that is either a parent is unable, meaning they perhaps are detained, incarcerated, otherwise incapacitated, or there's a court order preventing them from having contact with the child. So, in instances, for example, with domestic violence, if an order of protection has been issued that gives one parent sole custody of a child and sole decision-making authority, a second parent's consent to the guardianship is not required. And then the final way that guardianship doesn't need both parents involved is if the parents are unmarried and parentage has not been established by a court order. So if a child has only one parent listed on their birth certificate and the family has not made any efforts to get like a parentage order declaring most commonly a father to be the child's parent, or if there's not a child support order, because again, that would require establishing parentage as a precursor. So this is a question that kind of comes up depending on a family structure. I do have a one pager that Diana is going to share out later that goes over some of these questions as well. It's also not a way to terminate parental rights. So again, if you think back to the first slide, a child has at most two parents. If one parent disappears, they still have one parent. If both parents disappear, that's when you need a guardian. You cannot have one parent and one guardian involved. So a guardian doesn't replace an actively involved parent. A guardian steps in when there are no parents. So if there's dispute between two parents, they can't use this form as like a way to cut the other parent out of a child's life. Guardianship also importantly is not unlimited. So unlike permanent or plenary guardianship, there are some limitations on what a legal guardian can do. The short-term guardian cannot obtain a passport for a child. This is really important for families who are of mixed immigration status and even mixed citizenship status. If a parent is deported or voluntarily leaves the country and they want their child to either visit them or reunite with them in another country, the child is going to need a passport before the parent leaves. And that is because the US passport form requires both parents' consent and oftentimes their presence or a notarized affidavit to get that application filled out. A short-term guardian is unable to obtain a passport for any children that are not their own. It is also not absolute protection from DCFS. So as I mentioned, this is a way to prevent DCFS from stepping in where there's an absence of authority, but this does not mean that in the future, if a guardian is suspected of harming the children or abusing or neglecting them in some way, that DCFS won't get involved. DCFS still has the authority to investigate situations of abuse and neglect, and a court can also intervene and remove the children from a short-term guardian if needed. And again, as I mentioned, a guardian does not have control over a child's assets. So things like a bank account that's on behalf of a child, if the child is the beneficiary of a trust or receives, for instance, Social Security benefits, things like that, the guardian does not have any access to those funds and cannot use them in any way unless they are separately given that authority through those distributors of funds. The guardianship form does not give them that authority. And then finally, and this is very important, oftentimes for the communities that we're most often seeing using this form is a legal document. It is a legal authority, but it is not creating any pathway to legal status in the United States for the parent, the child, or the guardian. So by filling out this form, you're not creating a situation where in the future you can get legal status in the US. It also, unfortunately, will not prevent children who do not have legal status in the US from being detained or deported. So if a parent is with a child and the parent is detained and the child's with them at the time, and they're going to detain the child as well, the parent unfortunately can't say, no, I've appointed this person a short-term guardian, the child should go with them. If the child has legal status here or is a US citizen, the guardian should be able to take custody of the child. I will say we have seen situations where unfortunately immigration enforcement isn't checking or caring about the legal status of the folks they're detaining. So it's not a fail-safe. But for children without status, this does not provide protection from them being detained or deported as well. So we're going to talk about the role of guardians. So when you're talking with parents or parents have questions, this is a list of qualifications that they have to meet. So they must be at least 18 years old. Again, they have to be legally an adult. They must reside in the United States and in Illinois. So the guardianship form, again, is state specific and it assumes the child and guardian both live in Illinois. A guardian cannot have a felony conviction history. There are some exceptions to that, but it requires going to court, which kind of defeats the purpose of using this form as a way to avoid having to go to court. So we recommend that if someone has a felony conviction, you look elsewhere for a potential guardian. They can have no history of child abuse or contact with like the Department of Children and Family Services in the last 2 years. Now, if they're serving as a foster parent, if they work for DCFS, if they are some way connected to DCFS through employment or volunteering, that's absolutely okay. What this is meaning is that they cannot have been accused or suspected of abuse or neglect of a child. They must be of sound mental capacity. So, similar to a parent's incapacity, this doesn't mean people with mental health diagnoses or other disabilities or if they take particular medications, that doesn't prevent them from being a guardian. What the law is concerned about is that the person being appointed guardian, even with those sorts of diagnoses or conditions or medications, is still able to act as a parent. So, as long as they can do that, that is completely okay. And then finally, you cannot have been adjudicated disabled by a court. So this is referring to adult guardianship. The way to remember this is that you can't be someone's guardian if you yourself have a guardian who's taking care of you. And then these are questions that we recommend parents think about. These are not requirements, but they're good things to consider and plan for when selecting a potential guardian. So it should be someone who is both able and willing to meet the child's needs. So a short-term guardian is obligated to provide medical care, education, housing, food, and clothing for the child they're caring for. And there is no, unlike a permanent guardianship or other kinship care plan through let's say DCFS, there are no subsidies, there is no financial support, there is no pool of money that these guardians can access. They have to be able to meet the child's needs on their own. Now, a parent may have financial resources that they're planning to like send to the guardian. That's completely okay. But the guardian is ultimately the one obligated to make sure the child's needs are being met, both financially and then just in the real world as well. It should be someone who's trustworthy. This seems obvious, but especially in these cases where we're talking about family separation, the guardian is often the one who's going to be facilitating the phone calls, emails, visits between a parent and child. And so you want someone who's going to like take that role seriously and be willing to continue your parent-child relationship. It also is important since the guardian's likely to be the conduit of information for a parent with like updates about how the child's school is going, updates on medical care. You know, obviously as children get older, they can provide that information to a parent. But we want parents to feel comfortable that the person they're appointing is going to be upfront with them about what's going on with the child. We also recommend it someone who knows the child. Again, this may seem obvious, but sometimes, you know, parents may have people they very much trust who maybe their child just doesn't see a lot. We recommend it someone who knows the child because ultimately the child's going to be living with this person if a guardianship is needed. This person's going to be taking care of their day-to-day needs and very involved in their life. So it just provides a degree of stability and security to the child to know who that person is and feel comfortable with them. It also is helpful. We've unfortunately seen situations where parents might be detained while their child is at school, and the child is either coming home to an empty house or is not being picked up from school. So it's good for the child to know who to expect or who to reach out to if their parent suddenly goes missing. It should be someone who knows the parent's plans and wishes for the child and is willing to follow them. So a legal guardian, you know, has those obligations to meet, but there's no requirement that they do them in any preferred way. So if a parent has, for instance, a particular religious practice or school plan that they want for their child, like let's say private school or homeschooling, things like that, and a guardian's not obligated to follow those wishes for a parent. It's certainly something we'd hope they would do. But again, when a parent's thinking about who to appoint, they should really give some thought to who's going to kind of raise the child in the same way the parent would hope to. Would the parent still be there? We also recommend it's someone who can travel internationally with the child if that's what the family wishes. Certainly, children are able to fly unaccompanied depending on an airline's policy, and also depending on what visa status or citizenship a child holds. But oftentimes, for especially really young kids, it's going to be someone accompanying them. So it should be someone who's able to travel as needed. And then we do recommend it's someone with legal status in the US. This is not technically a requirement of the form, but the idea of filling out this form is we're creating stability for the children in the event of a separation. We don't want to create a sort of domino effect situation where a parent is detained and then a guardian steps in, but the guardian also doesn't have legal status. So they're at just the same risk of detention as that parent was. And it could create a situation where the child is again left with no one to care for them. All right, so the short-term guardianship form, this form, again, it is a legal form. It's going to feel very informal, though, because it doesn't have to go to court. It doesn't have a fee associated, doesn't get registered. You can download it from the Department of Children and Family Services website. I think Diana is going to put the forms in the chat as well. It's available in both English and Spanish. We do recommend parents fill out the English version, even if Spanish is their preferred language, and that's so that authority figures like schools, doctors, childcare providers have easy access to the form. So it's a 4-page form. On the first page, and everything that's not in a purple line is on the form. So it asks for the parent's name and the address, and then the name of the child. So with this form, a parent can fill it out at the same time as the second parent, or they can fill it out and sign it at separate times. If two parents are filling out the form, they can both put their information here. It's a pretty tiny line though, and there is a spot for a second parent at the end. So we often recommend that if two parents are present, they just use that second line on the last page as well. The reason it asks for an address is just as a way of identifying who the parent is. And then the name of the child, each child needs to have their own form. So even if all the parental information is the same guardian is being appointed for the children. Each child needs their own form. So if a parent has one child, they'll fill out one form. If a parent has 4 kids, they're filling out 4 forms. And that's just a way of making sure that each child's providers get the correct information and don't get extra information they don't need. Question 2 asks for the name and address of the person to be named as guardian. Again, it asks for the address because it's a way of identifying someone. So if I'm appointing John Smith to care for my child, I'm going to want to put it's the John Smith who lives at 123 Main Street instead of the John Smith who's at 456 7th Street. It's just a fail-safe so that if a doctor or a child care provider has a question of like, are you the right person? It's a way to identify them. I know sometimes we get a lot of questions, people being hesitant to put that information on a form. Again, it's not used anywhere. No one has access to this unless you share it with them. So I understand the privacy concern, but again, it's necessary as a way to identify the correct individuals. Page 2 of the form is where this administrative separation and date language can be used. So the effective date is when the guardianship would begin. You can see here on the form, and these are all pre-printed on the form, other than this language about the administrative separation. There's a lot of options parents have. We again recommend for the most long-term coverage that you just use on the date of administrative separation. You don't have to include the actual language from the statute on the form. Our templates do, just so that someone has reference to it. But since it is in the statute and has a definition, it's not required to put this whole paragraph on the form. And then termination, similarly, a parent has a couple options. If they know a particular date that they're going to be reuniting with their child, they can absolutely put that on there. Again, though, the more broad the language is, the longer the form can last and the more useful it can be. Page 3 is where signatures come in. So this is the most critical part of the form in terms of making it valid. So the form requires the signature of one parent and 2 witnesses at the same time. So the parent will sign the form. If both parents are there, again, they can both sign here. There's not a ton of space, so there is the second line on page 4, but the 2 witnesses need to sign it at the same time as the parent. at least one of the parents. The two witnesses also should be adults. They should not be the guardian being appointed. It should also not be the second parent. So generally, it should be someone we recommend like unrelated or like a neighbor, family friend, something like that. Again, their name, their address are on here just as a way to identify them. If someone were to have a question about the form, someone would have to affirmatively go to court and question the validity of the form, though, so this doesn't come up a lot. And then the other signature that's needed on page 3 is the signature of the short-term guardian. The short-term guardian can sign at a later date. Their signature does not need to be witnessed. It doesn't have to even occur on the same date as the parent's signature. But in order for the form to be valid, the guardian does need to sign the form. So a parent can't just complete their part of it and say like, oh, the guardian will sign it when the guardianship goes into effect. That is not okay. The guardian needs to sign the form ahead of the guardianship going into effect. So these signatures on page 3 are the bare minimum that are needed for the validity of the form. Page 4 is where that second parent signature comes into play. So again, if a second parent is present and filling out the form at the same time, they can fill it out right here, sign it, same day, everything. They can also sign it at a later date if a parent's at work, if they live separately, whatever reason. If the second parent signature is not required, again, for one of those 4 reasons, being deceased, unknown, unable to care for the child, or parentage hasn't been established, this part of the form doesn't have to be filled out. But the best practice is if the second parent is known, they should be filling out this form. And then we have some reminders and recommendations. So after the form is completed, that's all that a parent has to do. Again, it doesn't get registered anywhere. It doesn't have to be reported to anyone. We do recommend giving copies of the form to the person being named as guardian, the child's medical provider, the school, any like daycare or after school programs as well. It's not required that the parents share that information ahead of time. But we do find it can make for an easier transition and give the school like the time to ask questions to verify they understand the family's wishes, things like that. But the form, again, doesn't have to be sent anywhere. We run a number of clinics where we fill out these forms for people. We don't keep a copy. It is a very private form between the family and whomever they share it with. Now, a guardian will need to share the form when asked once a guardianship goes into effect. So a guardian should be prepared to hand out copies as requested. So some reminders, each child needs a form completed for them, even if all the other information is the same. That parental agreement is really key. If you know the second parent is not going to agree, for whatever reason, we really recommend not filling out this form. And that's because the second parent will always have a right to challenge the form. And that can lead to just a lot of conflict in families and more instability for children. So as much as possible, try to get to that parental agreement. Maybe there's another person that both parents are like, not thrilled about, but like comfortable with naming. And maybe that's the better option for a family. Again, a reminder that the legal status, it's not a requirement, but we strongly, strongly recommend it. Someone who's a U.S. citizen or legal permanent resident. You know, we have been seeing that even legal permanent residents are getting picked up by law enforcement, or their status is being questioned. So if possible, U.S. citizens are probably like the most secure option. But at a minimum, we do recommend a citizenship or a permanent resident. As I've said a couple of times now, the guardian and child must be living in Illinois because each state handles this matter differently. And then a few caveats to who can use this form. So for children who are going to turn 18 within that 365-day period, the guardianship will not last 365 days. It will terminate on the child's 18th birthday, and the guardian's obligation to care for the child will also terminate. So what this means is that, you know, hopefully the guardian would continue allowing this new adult, an 18-year-old, to stay in the home, will continue helping them as needed. But if, let's say, the 18-year-old and the guardian are not getting along, the guardian could essentially kick the 18-year-old out and wouldn't have any legal obligations to care for them anymore. So we just like to make families aware of that, that once a child's 18, they're technically considered an adult and are responsible for their own livelihood and care. And then this doesn't come up frequently, but in the event that a child under the age of 18 has gotten married, they cannot have a guardian appointed for them. Marriage of a minor bumps you up into like this weird quasi-adult status where you can't have a guardian. And then finally, we do often see that parents have some additional questions that they'll come up as we're talking about this, sort of safety planning questions at this time. As Diana mentioned, we aren't seeing as much immigration enforcement as we were last summer and last fall, but it's certainly still occurring. So if a parent has more specific questions about their situation, we do recommend they speak to an attorney. Things you may hear a parent talk about are self-deportation or voluntary departure. With the understanding that nothing in this kind of situation is really voluntary, given the situation, a lot of parents are feeling forced to make this decision. But if a parent's talking about leaving the United States, we really recommend that they speak to an immigration attorney. That type of departure, if they are not here legally, or even if they are, or their status is pending, it can create a lot of legal consequences that may jeopardize their future status or ability to return to the U.S. If a parent is talking about maybe they have a very young child, 2 or 3 years old, and they're going to be leaving the country, or they know they're going to be deported, and they don't expect to reunite with that child while the child is under the age of 18, we would recommend a family look into something like long-term guardianship. Again, it gives more authority to the guardian. And allows more stability for the child, things like financial decisions, other areas of law that the short-term guardianship doesn't cover. So if it's a parent who's got a really young child and they know they're not going to reunite in the next 1 to 2 years, we would really recommend they look at more long-term options. And then for parents who are not U.S. citizens and their children are also not citizens, so if they need a passport from another country in order for their child to travel, we recommend they talk to their consulate or embassy or an immigration attorney. Right now, there is a pretty significant issue in that the United States does not have diplomatic relations with Venezuela. So there is no consulate, there is no embassy, there's no way to get a passport in the United States from Venezuela. So that's something that people should consult with an attorney. I know there are some support groups for Venezuelan refugees in particular that have been dealing with this as well. And then parents may also have questions about like financial documents, things like that. A power of attorney form is a great option. I'm not going to get into that today, but that's, again, something that an attorney would be able to talk with them about. And when I say they should talk to an attorney, we also just want to flag that there are so many free legal resources and attorneys willing to assist people without charging them, that if a parent is talking about, oh, I have to, they're filling out the form and they're like, oh yeah, I'm going to the bank after this to get a check to deliver to a notario to get me my immigration papers. That's a big red flag. No one should be paying that much upfront for the promise of forms, the promise of an application, the promise of status. It is true that some forms of legal immigration applications, they do require fees and things like that. But typically, that's going to be a lot further down the process, and that's going to be a more legitimate attorney-client relationship. So if you're hearing from a parent that they're being asked to pay a bunch of money, it's always good to recommend that they talk with a legal aid organization or other nonprofit who's providing legal services. These are just some of the ones we recommend. LAS is also able to consult with people. But at this point, we're fortunately in Chicago, we have so many legal aids and other organizations that have really stepped up at this time to make sure folks are getting the information they need, getting accurate information, and getting information that doesn't come with a high price tag. So these are just some of the resources that we recommend, but it really shouldn't be that people are having to like empty their bank accounts to get legal advice at this time. So that's everything I have for today. This is our intake line for LAS. We do cover some immigration matters. We also do, like I said, family law, housing, and related issues. So if anyone has questions or knows folks who do have questions, they're welcome to call our intake line. If we can't provide the services that someone needs, we are able to make recommendations of who else they should reach out to. So we really encourage whoever might have questions to reach out to either us or another legal aid and get some of that assistance. So with that, I believe we're going to stop the recording and then turn it over for questions.